प्यारा Mr. K.T. Dave, learned additional public prosecutor appearing for the state, while replying to the contentions raised by the learned advocate for the appellant, submitted that he supports the judgment and order of the learned additional sessions judge in toto. He submitted that the learned judge has taken all pains to consider all these contentions at the time of trial and has given convincing reasons for not accepting any of them. Mr. Dave also submitted that the learned advocate for the appellant has tried to mislead this court by not pointing out that he himself has appeared in Criminal Appeal number 12 of 2002, wherein all these contentions were taken but were not accepted by a division bench of this court, consisting in their judgment dated 5th-6th February 2002. Mr. Dave submitted that more particularly first two contentions, namely Section 57 of the NDPS Act, is held to be mandatory by the Honorable District Court in the case of Dinkar (Supra) was put forward for consideration of the division bench, and the division bench in its elaborative judgment have turned down the same for the reasons set out in the judgment. He submitted that, so far as Section 52 is concerned, it was also argued, but the same is also turned down. Mr. Dave, learned APP, submitted that even the argument that Section 50 can be said to have been complied with only when the officer concerned state to the accused that he has a right of being searched in the presence of a gazetted officer or a magistrate was advanced, but the same was negatived by the division bench, relying upon various decisions of the Honorable Apex Court. We are at pains to record that a senior advocate owes a duty to the court to point out a judgment, more particularly when he himself had appeared and argued the matter before another division bench, more so when it was another public prosecutor who had opposed him. It is not in good taste to argue a matter by urging the same points after before this court without mentioning that he has already argued those points earlier before another division bench and they are concluded against him. We would have appreciated the submissions if they were to the effect that in view of the latter decisions of the Honorable Apex Court, he wants this court to take a different view of the matter than that of the earlier division bench. But then he did not do that. He argued the matter without even mentioning the aforesaid fact. It is painful that a senior advocate has not discharged his duties towards the court and has not put any serious effort to see that ends of justice is served. An advocate has to advance a cause of his client, but at the same time, it is his pious duty and obligation towards the court as well as towards the other side to point out the decision which may not be favorable in his case. Here, in this case, the learned advocate who appeared before the earlier bench advanced all these points at length, which are concluded against him by a judgment, made an attempt to suppress that judgment, and argued the matter afresh, and urged all those points afresh with a hope that he may obtain a judgment in his favor, despite this fact, as what is at stake before us is the interest of the appellant and not of the advocate. We have considered all the submissions of Mr. Agarwal, learned advocate for the appellant, in detail. We could have turned down all his submissions on all these points merely by saying that all these points are concluded by a division bench judgment.